Hello, my name's Andrew Underwood. Some of you may know me, others may not. For those who don't, I am running for U.S. House of Representatives to represent uh, Northwest Georgia at District 14. I am here today to talk to you about issues regarding ballot access, particularly from my perspective. Now, ballot access is a really important issue to me. So I'm going to try and start at the beginning here. All the way back in 1776, a group of colonists picked a fight with the most powerful empire on earth. Now, over 4 words: no taxation without representation. It's worth pausing on that phrase, because 250 years later, most people misremember what it actually meant. It wasn't a complaint about the tax rate. The colonists weren't out there with protest signs demanding a lower percentage. What they were saying was something much simpler and much more radical. You cannot govern us and give us no voice in how. That's the whole argument. Not the amount, the voice. So I want to be honest with you about something before I go any further, because I think it matters to how seriously you take the rest of what I'm about to say. The colonists had 0 vote. They were not electors in Parliament. They had no seat, no ballot, no say at all in the decisions made about how their lives 3,000 miles away were going to be impacted. What I'm about to talk to you tonight is not that. I have a vote. You have a vote. Nobody in Georgia is being told they can't walk into a polling place. But I'm going to argue tonight that we've quietly let representation shrink down to mean something much smaller than what it was supposed to be. We've let it mean access to a ballot box, where it was always supposed to mean access to a real choice once you're standing in front of it. Here's the sentence I want you to leave with tonight. I'm going to say it a few times because I want it to stick. Representation without options is taxation without representation, just with extra steps. A voice that's only allowed to say one of 2 pre-approved things isn't really a voice. It's a script. And tonight, I want to walk you through exactly how Georgia built a system that hands nearly every voter in this state a script instead of a choice, and why I think fixing it is the next chapter in a fight this country has been having since before it was a country. Now, I'm not speaking out of theory here. I know firsthand. I filed to run for the U.S. House in Georgia's 14th Congressional District as a Libertarian candidate. And I want to walk you through what that actually looked like, because I think the mechanics matter more than the outline. The filing fee alone was a hurdle. I had party support that covered 3/4 of it, and I had to pay the rest of myself out of pocket before I could knock on a single door or buy a single piece of campaign literature. That's before the actual work of campaign ever even started. Then come the signatures. Under Georgia law, to get my name on that ballot, I needed to collect notarized signatures from voters equal to 5% of the registered voters in my district. In practical terms, that meant roughly 29,000 signatures Not names, notarized signatures, meaning every single one of them had to be signed in front of a notary public, verified, and submitted within a 4-month window. Think about that means logistically. Every signature costs time, and we're looking at more than 240 signatures per day on average. And notaries don't work for free. Every dollar spent on notarization is a dollar unavailable to spend on yard signs, mailers, a website, ads, the actual work of telling voters who I am and what I believe. It made it hard to campaign because it forced me to spend the bulk of my limited resources clearing a bureaucratic hurdle before I ever got to introduce myself to a single voter as a candidate rather than a petitioner. Meanwhile, the Democratic and Republican nominees in that same race don't need to collect a single signature. They didn't sit outside a grocery store on a Saturday morning. They didn't pay a notary. Their names were placed on the ballot automatically because their party crossed a vote share threshold in a prior statewide election. Nothing about their individual candidacy had to prove anything to anyone. I'm not telling you this to complain about how hard my race was. Elections should be difficult. Convincing people to trust you with their vote should take work. What I'm telling you is that Georgia has built a system where an enormous share of that work has nothing to do with convincing anyone of anything. It's just clearing a wall that exists for one purpose and one purpose only: to keep the number of names on the ballot as small as possible. The wall, okay. Let's talk about that. Let me put some precision on what that wall actually is, because I think specifics matter more than the outrage. Georgia requires a third party or independent candidate for the U.S. House of Representatives to collect signatures from 5% of the registered voters in that congressional district. Not 5% of the people who vote in a given election, 5% of everyone registered, whether they've cast a ballot in 10 years or 10 days. A single Georgia congressional district that typically, in a single Georgia congressional district, that typically works out to somewhere around 25,000 signatures. For a full statewide slate of U.S. House candidates, that number climbs into hundreds of thousands. As of the most recent count I've seen, over 360,000 signatures would be required for a party to run a complete slate across all 14 districts. Compare that to the major parties who need 0. That's not a typo. It's not an exaggeration for effect. The Democratic and Republican nominees appear on the general election ballot automatically by virtue of their party's performance in a prior statewide race. No petition, no notarization, no 4-month clock. The 5% wall exists exclusively for everyone else. And on top of the raw number, there's the friction I described a moment ago. Every one of those signatures has to be notarized, a cost and logistics burden the major party nominees simply never encounter. There's a qualifying fee calculated as a percentage of the office's salary. And there's that clock, a fixed window, typically well under half a year, to gather tens of thousands of verified signatures while simultaneously trying to run an actual campaign. Here's the number that I think should stop this room cold. Since this law took effect in 1943, no third-party candidate has appeared on the general election ballot for U.S. House in the state of Georgia. Not one. In 83 years. Not because no one has tried, not because Georgia has no political appetite outside the two major parties, because the wall works exactly as designed. So it's worth asking, where did this law come from? Georgia's 5% requirement was enacted in 1943, not as some neutral piece of administrative housekeeping, but with a specific named target: keeping the Communist Party candidates off the state ballot. Whatever you think about the politics of that particular movement, notice the mechanism. The state didn't pass a law saying communist candidates may not run. That would have been transparently unconstitutional, and everyone knew it. Instead, it built a procedural wall, one that doesn't name a party, doesn't name an ideology, and is therefore much harder to challenge in court. Even though its entire purpose was to make sure a specific set of ideas never reached a ballot at all. That's important because it tells you something about how this kind of exclusion tends to work. It rarely announces itself. Nobody stood up in 1943 and said, "We are going to make sure Georgia voters only ever get to choose between two parties forever." They passed a signature requirement, a paperwork problem. And 80 years later, the paperwork problem has done exactly what it was built to do, just far beyond its original stated target. I want to walk you through what happened when someone finally tried to tear that wall down in court, because it's a genuinely remarkable story. And most people in this room have probably never heard it. In 2017, the Libertarian Party of Georgia filed a federal lawsuit, Cohen versus Raffensperger, challenging the constitutionality of the 5% requirement. In March of 2021, they won. A federal district court found that Georgia's ballot access law violated the First and 14th Amendments. The judge didn't split hairs either. The ruling described the cumulative effects of Georgia's requirements as having frozen the political status quo in the state's congressional races. That's not campaign rhetoric. That's the federal judge's written finding. That September, the court lowered the requirement from 5% down to 1% as an interim fix, while the state legislature was given the opportunity to write a permanent replacement. For a brief window, Georgia's ballot looked like it might actually open up. Then, in January of 2022, the 11th Circuit of Court of Appeals reversed that decision and reinstated the 5% requirement in full. Later that year, the case reached the U.S. Supreme Court. In October of 2022, the court declined to hear it. I want you to sit with the shape of that timeline for a second, because I think It's the most important part of the whole story. This wasn't a case where some fringe legal theory got laughed out of court. A federal judge, after reviewing the full factual record, agreed that the law was unconstitutional. And then a higher court put the wall back up anyway. And then the highest court in the country declined to say anything further about it. A federal court agreed that the law was unconstitutional. It didn't matter. That's not a failure of the legal system to notice a problem. The legal system saw it clearly. It's a demonstration of how deeply entrenched this kind of barrier becomes once it's been standing for 80 years. At a certain point, the courts start treating the wall itself as part of the landscape, rather than as the deliberate policy choice it always was. Here's a detail from that legal record that I think deserves its own moment, because it's the clearest evidence that this law was never really about ballot integrity or preventing frivolous candidates. If you run for a statewide office in Georgia as a third party or independent candidate, so governor, U.S. Senate, you need signatures from 1% of required voters. Or registered voters, sorry. If you run for a congressional district seat, you need 5%. Same state, same law, a 5-fold gap. And the only variable that changes is which office you're seeking. If the justification for a signature requirement is genuinely about screening out unserious candidates, there's no coherent reason that the bar should be 5 times higher for U.S. House than for a U.S. Senate seat. None. The only thing that explains that gap is that district races are cheaper and more winnable for an outside candidate, which means they are exactly the races that the two-party system has the most incentive to protect. And in case you're tempted to think Georgia has been quietly fixing this, consider what happened in 2024. The legislature passed Senate Bill 189, which did ease ballot access, but only for parties that are already ballot qualified in 20 other states or territories. That helps an already large, already national third party clear one procedural step. It does nothing, literally nothing, for an individual independent candidate trying to get on the ballot in their own district. The wall didn't come down. A side door opened for a small number of already established organizations, and everyone else is still standing outside. Now, I want to bring this back to where I started, because I think this is the part of the argument that matters most. In 1870, the 15th Amendment guaranteed the right to vote regardless of race. In 1920, the 19th Amendment guaranteed it regardless of sex. Both of those victories took generations of organizing, sacrifice, and in some cases, lives to win. I'm not going to stand up here and tell you that what I'm describing tonight carries the same weight. It doesn't. And I'd be insulting the people who fought these battles if I implied otherwise. But I want you to notice exactly what those two amendments actually secured. They secured who gets to hold a ballot. They did not, and never were intended to, secure what was printed on it. Those are two very different questions, and this country has only ever seriously fought about the first one. Georgia's 1943 law, the one that's kept every third-party candidate off the U.S. House ballot for 83 years, answers the second question by closing it off procedurally, without ever admitting that's what it's doing. A ballot with only two names on it, handed to a voter who fought generations just to be allowed to hold that ballot at all, answers who may vote and simply ignores what they're allowed to vote for. That's the through line I want you to take with you tonight. Representation without options is taxation without representation, just with extra steps. We've fixed who gets to stand at the ballot box. We've never seriously fixed what they find waiting for them there. I want to head off an assumption before I close, because I think it's the most natural one to make, and I think it's wrong. The lawsuit that nearly tore this wall down was brought by libertarians. It would be easy to hear this whole speech as a pitch for our particular third party. It isn't. The exact same 5% wall that has kept libertarian candidates off the ballot for 80 years does precisely the same thing to a Green Party candidate, a Constitution Party candidate, or an independent candidate with no party label at all, who simply doesn't fit neatly into either major coalition. And here's the part I'd ask you to think about, regardless of which major party you currently support. Whoever holds power in Georgia today has every incentive to keep that wall exactly where it is, because the wall doesn't just block third parties, it blocks competition. Period. That's not a Democratic problem. It's not a Republican problem. It's a problem for anyone who believes that elected officials should have to actually earn their seat against a real field, rather than inheriting it because the field was never allowed to exist. Let me bring you back to 1776 one more time. The fight for representation didn't end at the founding. It didn't end in 1870 when the right to vote was extended regardless of race. It didn't end in 1920 when it was extended regardless of sex. And it isn't finished now. Not as long as the average Georgia voter walks into a polling place and finds a ballot that was substantially decided before they ever got there. I'm not asking you to tear anything down. I'm asking you to finish something that's been half built for 83 years. Support reform of the signature requirement in the Georgia legislature. Contact your state representatives directly. This is a state law, and it can be changed by the people who we already elect. And talk about this. Share this history. Most voters in this state have never heard the name Cohen versus Raffensperger, have never heard that a federal judge already ruled this law unconstitutional once, have never heard that it's been 83 years and 0 exceptions. They deserve to know that the ballot in front of them was never actually a free and open choice. And they deserve the chance to demand that it become one. Representation without options is taxation without representation, just with extra steps. It's time we finished what we started. Thank you.